SJC-11830, Commonwealth v. Melissa Lucas.
Good morning, Mr. Horstman. Why don't you wait a moment until we get all the students in?
Thank you.
I don't want them to miss a word of yours.
Nor do I.
All right. You may proceed, Mr. Horstman.
In a First Amendment case, it's very appropriate that we have so many ears here to listen to us. I think the Justice Kennedy said it best in the Citizens United case versus the Federal Election Commission, that it seems stranger than fiction that our government should make political speech a crime. And that's really what has happened here with this time capsule that has been unearthed in this case called Chapter 56, Section 42, which has been on the books since 1946, but has been very, very seldom employed by anybody. The premise of the Commonwealth's objection to the declaration that this statute is clearly unconstitutional on its face is that false speech, especially in this context, is somehow dangerous to the free election process. And that, quite candidly, has been refuted by the Supreme Court in recent opinions and doesn't even pass the logic test with respect to what we have seen in the last two presidential election cycles. The truth doesn't die because of a false statement. The truth dies because the government creates a law or a civil practice that doesn't allow the truth to come forward.
Well, this is not in a vacuum. There are many false statement statutes, false statements to the government for materiality, false statements to a police officer. Certainly the Commonwealth has a chance to refute those. So if you're right, do those go out the window too?
Absolutely not.
And how do you what's the difference between the many false statement statutes that are out there and this false statement statute?
And I think that applies equally to the government's fraud analogy here as well, which is that those statutes are narrowly tailored to the point where they actually achieve a government goal. And the example that's given in the Alvarez case by Justice Kennedy is trademark infringement. That the trademark infringement statute clearly is narrowly tailored enough to the point where it's not going to encapsulate the core speech that's involved here. And that's really what's at issue. We're on hallowed ground here. This is the most protected form of speech.
So if somebody, the day before the election, somebody accuses one of the or makes a statement that one of the candidates was convicted of raping a child 15 years ago, and it can be shown that the statement was knowing, and it was made with knowing as a knowingly false statement, that wouldn't be that wouldn't come within this statute?
No, it would not.
It would be protected.
It wouldn't be protected. The person accused of the crime would certainly have the civil remedy that's available, but to make it a crime in the context of an election, and it wouldn't stand on the same footing as the speech in this case, because what we're talking about here is speech that is critical of a government employee who's in office at the time. And it occurs during an election campaign. So what happens here is even more protected than some personal attack on an elected official during a campaign.
Is that because it's opinion?
Well, it is opinion in this case. I certainly agree with that. I do think opinion, political opinion, is that is completely immune from this statute.
And you would agree that opinion is not criminalized by this statute?
I agree with that wholeheartedly. I don't think that...
One of the problems, of course, is who decides what's false fact statement and what's false or what's an opinion statement.
Precisely. And the Supreme Court has not been favorable to the notion that there's this entity out there called the Ohio Election Commission that can somehow be the arbiter of truth and falsity in the state of Ohio. What we're doing here would seem to me to be far less predictable and less certain, and that is to entrust a very well-intentioned, probably underpaid for this assignment, clerk magistrate in a district court to be the judge of what constitutes political truth and falsity in the heat of a raging election where parties are saying all sorts of things about each other.
The clerk doesn't do that. The clerk doesn't make that decision. That's a decision that's made by a jury, ultimately, if the complaint is brought to trial.
It shouldn't even go that far.
No, I get your point, but I'm just drawing out that you're overstating the issue. While I have you, let me just say, I've read your brief and I read a lot of the amicus briefs, and I'm really, really very sympathetic to this idea that the marketplace of ideas is central to democracy. That sounds great if there's a level playing field for everybody who wants to speak. And that's clearly not the case. So how do we level the playing field for people who don't have access to the platform, but the marketplace is flooded with all of these half-truths, outright lies? I mean, we all know that that's what happens in the example that Justice Spina just gave. So why isn't there some value to protecting access to the marketplace of ideas? And this statute could be seen as a way of doing that, because it would keep out the people who are going to flood the marketplace of ideas with these ridiculous notions such as what Justice Spina just talked about.
Well, I think the first response is that it almost loses its significance whether we call something fact or opinion. To protect something merely because it's someone's opinion versus a stated fact, it sort of loses its value in the marketplace, where all somebody has to do is change the syntax of what they're saying in order to be able to say it. I think the concurring opinions in New York Times versus Sullivan actually set forth the better remedy, which is that no political speech should ever be the subject of civil penalties or criminal penalties by any government, any state government, any federal government. And there were 3 Supreme Court justices who felt that way at the time. Justice Douglas, Justice Black, and I think Justice Goldberg.
So it's really well before Justice Spina's example that the person who has been falsely accused of having been convicted of rape can't later bring a libel action?
Well, first of all, it's a public official, so
Well, I understand, but they can still bring a libel action.
Absolutely,
Surely
no question about it.
Surely they could. That's not an issue here.
But the cases you're talking about, that's a completely different environment, and I think you quoted citizens. I mean, the level playing field is not so level. As you can see, what we're doing now is really fueling all of this kind of speech, and whoever has the most money gets to flood with more of this kind of speech.
I think I look at it differently, and I can give you 2 examples. In the 2 most recent presidential election cycles, we've had notoriously false statements that have leaked out, as Your Honor has described it, into the marketplace of ideas, where the candidate's opponent actually had to come forward and announce the falsity or highlight the falsity of the statement. I mean, we all can remember John McCain addressing the town meeting participant who accused the president of being a Muslim. And there's no greater pronouncement of a falsehood than to have it corrected by your opponent during a presidential election campaign. The same was true for Governor Romney. When Harry Reid said on the floor of the Senate that he hadn't filed his tax returns or paid his taxes in the last 10 years, the president's election team was forced to come out and admit that, that's not entirely accurate. And Harry Reid's never been called on the carpet about that. So you have this balance here that is achieved through the use of a podium, such as a platform, such as a candidate's ability to get in front of a microphone and correct it. And we saw what Mr. Mantle did in this case. Mr. Mantle was able to hold a very effective press conference in which he denied the allegations that he said were false and was able to move on. He didn't need the full weight of the application for criminal process in the Barnstable District Court to aid him in that. He was a candidate. He could have gotten a camera at any time, could have gotten a microphone at any time. The Cape Cod Times is following him around. It wasn't a hard thing for Mr. Mantle to do. So while I understand the need to correct the falsities in the marketplace, I think the system allows for that, and I think it does balance itself out. The greater risk is that someone is charged with a crime for stating a falsehood.
Or investigated.
Or investigated.
During an election cycle.
Correct. Chilling the speech of not only that person, but anybody who shares that view. And I think the CARE Committee case was very adamant about that. That's the Eighth Circuit opinion on the Minnesota law. And I think the Susan B. Anthony List case drew the same concern, that there is no remedy once the speech has been chilled. And in particular, the Citizens United case, which concerned the Hillary Clinton video, the Supreme Court said, after announcing its opinion, that it took 2 years for Citizens United to learn whether they could produce, to show this video to the American public or not. In the course of an election cycle, that's just not timely.
I'm trying to flesh out your argument a little bit. I mean, you basically conceded that there could be a defamation action with regard to a false statement, correct?
Under
a civil defamation action.
Under the scenario set forth by Justice Spina.
And that means then, I guess, that falls into the category that knowingly false speech is not protected speech because you can get damages as a result of it.
There's a lot more to defamation action than just false speech.
My position is the closer you get to the hallowed ground of this case, that is the criticism of a government official during...
You say government. It's not limited to a government official, is it? It's a candidate.
Candidate, but...
It need not be the incumbent.
No.
Well, I think when you're criticizing government itself, you have heightened protection.
But
That's core speech.
would it be different if they were criticizing the person who was not the incumbent and saying that he had the rape conviction?
It wouldn't differ my answer to your question, but it might result in what the Supreme Court has called intermediate scrutiny as opposed to exacting scrutiny.
Well, I'm not sure that I don't think you necessarily have to go that far. I mean,
I'm not sure I do
it
either.
is part of the campaign, public election. I mean, it seems to me that's political speech, whether you're an incumbent or a challenger.
Certainly, that's true. The difference the distinction I was drawing from the analogy that was presented was it was a personal attack. It wasn't necessarily a criticism of the way in which Mr. Mantle votes on certain laws that he proposes or what laws he introduced. That the Supreme Court has clearly found to be the most sacred of political speech on hallowed ground, not necessarily what somebody does in their private affairs. So that's why I'm saying that the hallowed ground here is so important because of where this speech is coming from, and we dealing with this marketplace of ideas concept. We're in a place right now where we've got special interest groups and we've got PACs that have an agenda, good or bad. They have an agenda. And does the actual malice standard actually fit the criteria where you have a special interest group that has a position on a topic? Just because they have a specific issue that they support, whether it's gun control or anti-gun control or whatever, does that necessarily make it, does that satisfy the ill will standard because they're against any candidate who takes that position? I think that needs further clarification.
I guess part of what I'm trying to flesh out is, are you arguing that you should win because false speech has affirmative value, or that you should win because criminalizing false speech in an election campaign would chill too much speech?
We should win because the First Amendment does not permit the government to make categorical distinctions based on the content of speech, and that's what's happened here. There's a categorical distinction that has been made.
Well, that's a much broader statement because it does all the time with regard to false statement statutes.
But that speaks to the overbreadth of the statute. We haven't narrowed it to the point where we're even at the point where we're talking about the language of the statute. I'm happy to answer any further questions, but I see my time is up.
Okay, thank you.
Thank you.
Morning, Your Honors. Amy Spector for the Commonwealth. Your Honors, because political speech is absolutely critical to our democracy and the First Amendment, Section 42 has to be narrowly construed, and we believe that the charges should be dismissed.
Is there any way of construing it narrowly that survives? I really wonder about this. What is the compelling government interest?
Yes, there is. There is a way of construing it narrowly. I just want to point out that here the court really need not reach out to decide the constitutional question because the statute clearly does not apply
Well,
to the
if it's so
statements.
clear, why did it take the Attorney General so long to say so?
Your Honor, we recognize that the court may not be happy that the case is here. The Attorney General did not and does not represent the Commonwealth in the course of the criminal prosecution that's ongoing. And
did you have an appearance in the First Circuit?
We had an appearance in the First Circuit, but the statutory issue was not, we didn't have occasion to address it there. It was not until the district attorney informed this court in early March that he was declining to file a brief that our office filed a notice of appearance here, and the Attorney General felt that it was her duty to represent the interests of the Commonwealth here. But if the court decides to grant 211(3) relief, it should limit its ruling to the statutory issue and dismiss the charges against.
But you say it's so clear. There's nothing clear about the language of this statute. I mean, you argue as though the language said, A, we only reach fact, which it doesn't, but B, that clearly it only criminalizes false, fraudulent, or defamatory speech. I just don't know where you get these limitations in the language.
Well, Your Honor, we recognize that the statute only survives scrutiny if it is narrowly construed. But again, we respectfully suggest that where the statute doesn't even apply, the court...
Why doesn't it apply?
It doesn't apply because these statements are clearly opinions. It's important...
So clearly that a clerk magistrate issued a criminal complaint, that clearly?
Well, I think in this case, I think the clerk issued a complaint based on statements that are our opinions, but that doesn't mean that it's going to happen again, and particularly if this court... Well, if this court issues a decision...
Don't we have many cases that say if this is a distinction between fact and opinion are quite hard to sort out?
The clerk magistrate going to know that from the language of the statute, even that it is fact versus opinion?
I think with all respect, it is a common sense inquiry, and particularly if this court issues an opinion that emphasizes the narrow reach of the statute, that will inform and provide helpful guidance to clerks and judges with respect to the narrow reach of the statute.
But what about the timing of this? Let's just say that that an opinion of this court will at least explicitly say this doesn't reach opinion. But in every case, determining what is fact and what is opinion, you know that's not an easy matter. And so somebody gets a complaint, and then the election is over. I mean,
Well, the fact that the statute has been very rarely invoked in the almost 100 years since it was enacted, I think speaks to the fact that it's not chilling speech, and this
Not
is a
yet.
very...
That may be because nobody knew of it, and maybe they'll learn of it as a result of this opinion.
Well, again, though, if that were the case, I mean, we have many statutes in which, in any case in which involving a regulation of speech that's a criminal case, of which we have many, the clerk is called upon to make a threshold determination. This is really no different from that.
But isn't sort of part of the problem in terms of the chilling of speech the fact that it would almost never be an adjudication of the matter, that it would only be a complaint which would be pending when the election is done, and the case would then be adjudicated after the election? I mean, won't the damage be done to say, I now have a criminal complaint that's been brought for my opponent lying about me? I mean, isn't that itself a weapon in the campaign?
It could be a weapon, but again, we believe that if the court emphasizes the narrow reach of the statute, that would minimize the problem. I mean, here we're talking about...
Well, how does that narrow it? So now it's now the SJC said this is a lie about a statement of fact.
Well,
this is not an opinion; it's a statement of fact, as limited by the SJC. It's you go into the election campaign, and then 6 months later, the matter is disposed of, and it turns out that it's dismissed.
Well, the statute, again, as narrowly construed, Justice Spina's example is a perfect example.
That is the
quintessential.
prime example. That's it. We're going to limit it to allegations of serious criminal conduct.
No, Your Honor, but allegations of that nature. So, for example, perhaps a serious crime or an allegation that was knowingly false, that a candidate voted in favor of particular legislation when, in fact,
we're going to legislative history, the various forms of amendments, and I mean that can be as complicated as anything.
Well, I'm talking about
before I was against it. It depended on the amendments. It depended on all kinds of things.
We're talking about a statement that the speaker has to make knowing that it is false. It has to be a material statement, and it has to be one that's capable of proving
And even if
false.
it's the type of statement that Justice Spina alluded to, that it is, I know that I'm accusing my opponent of a crime that I know he did not commit. I know that, and I say it. Why can't that be adequately addressed in a libel action? Why would you criminalize that kind of speech when the kinds of chilling effects on campaigns is just so omnipresent?
Well, Your Honor, I think that the legislature could well conclude that counterspeech is not an effective remedy, given the condensed time frame.
But could well conclude isn't enough, is it?
Well, I think that the concerns that several of Your Honors mentioned about the absence of a level playing field is exactly the concern that underlies the statute. That is that in the condensed time frame of an election, we know the reality that there are very well-funded, well-organized political groups that can easily skew discourse on the eve of an election. And in this narrow swath of speech that is knowingly false and essentially it's a form of fraud that is designed to trick voters.
Criminal fraud?
Yes, criminal fraud, to knowingly...
Because the other example of unprotected speech that you've given is defamation, and that is not criminal.
I'm saying that if it would fall under this statute. It is a crime to falsely, knowingly make a false statement about a material matter concerning a candidate. So we're talking about speech that is designed to induce a voter to change his vote. We're talking about something that goes to the heart of our election integrity.
But let me ask you this. You argue that we should be applying intermediate scrutiny to this?
Yes, Your Honor.
If it's a statement that's knowingly false about how, let's just say, this incumbent voted to let all sex offenders out of jail 42 times. That's what he voted that 42 times. You would say that's not political speech and therefore we apply intermediate scrutiny and not strict scrutiny to that?
No, that would be prescribed by the statute. Our position is that the court need not engage in a scrutiny analysis at all if it agrees with the framework we've suggested, which is that the speech that is targeted by the statute is not protected. It's outside the First Amendment. It's akin to fraud and defamation.
But if we don't agree with that framework?
If you don't agree with that framework, then our position is that the court ought to apply intermediate scrutiny following the controlling concurring opinion in Alvarez.
What do you think of the two, the Eighth Circuit opinion and the Ohio District Court opinion, both of which say Alvarez doesn't govern here?
I think that both of those decisions, I think, one of which is on appeal, both of those decisions, I think, fail to grapple with the concurring opinion's discussion specifically of political speech. Justice Breyer explicitly includes political speech in his articulation of how to apply intermediate scrutiny. Also, while the Commonwealth agrees that core political speech does stand on hallowed ground, we're not talking about core political speech
here.
How
do you know that in advance?
We're talking about...
If you're assuming that it's false, knowingly false, that's still not core political speech?
That's right. If somebody makes a knowingly false lie about a candidate that's material, that's not core political speech.
And you say for that, what case?
Well, I think Alvarez even supports that notion. The court there was dealing with falsity and nothing more, and they made emphatic...
That was in the Valor case, the Valor Act case,
yes,
right?
The Stolen Valor Act case.
And is that political speech?
Well, the court distinguished what was falsity and nothing more because it was not made in a context in which it could affect the integrity of a fundamental government process. In fact, the court specifically distinguished the Stolen Valor Act from the kinds of federal statutes that perjury statutes that prohibit lying to a federal officer, statutes that prohibit impersonating federal agent, all of which are statutes with, even without a proof of harm, the court said are statutes that affect fundamental processes of the government. And so the court distinguished those from a case involving falsity and nothing more.
Are any of those cases involving elections?
Those cases are not involving elections, although...
Statutes governing speech during elections, as this one.
No, they're not. Justice Breyer did cite but did not opine on. He noted that under an intermediate scrutiny test, he referred to, I think, a handful of cases that did involve political speech and suggested that a statute would have to be narrowly tailored in the political context, but we are urging the court to adopt a narrow construction of the statute that we advance. Again, though, I would just point out that there's no need for the court, in spite of the interesting constitutional question presented, there's no need for the court to reach that question here where the statute plainly does not apply to the statements at issue. They are not capable of being proven true or false.
And we know that because we've investigated, we've looked at it carefully.
I think it's a matter of common sense, Your Honor. This court's jurisprudence clearly states that statements that cannot be proven true or false are capable of multiple interpretations, and particularly when examined in the context in which they are made, are opinion statements. The statements here are strikingly similar to those that were made in Aldrich v. Boyle and that this court found to be non-actionable.
But the trouble is that this is a situation that's capable of repetition and constantly evading review on your theory that the statute doesn't apply to these particular facts, because we know that it was used in a way that could chill speech by virtue of the process itself.
Well, but that concern could exist with any of the statutes that regulate speech. And here, again, the fact that a mistake...
probably don't have the constitutional problems that this statute has.
Well, I think that if the statute is narrowly construed, it does withstand scrutiny. But I think, again, a construction by this court would certainly go a long way toward confirming the narrow reach of the statute and the very high bar that it sets. I guess unless the court has further questions, I'll just rest on my brief and again just emphasize that where the statute does not apply, we think that the court should not reach out and strike it down as unconstitutional.
All right, thank you. And we'll take our morning break.
All right.